Lord Panic, Mr. Tam, Ms. Anderson, Ms. Kilroy. This morning, the court has received the very sad news that our colleague, Lord Kerr of Tonaghmore, has died after a short illness. We express our deepest sympathy and our condolences to his widow, Gillian, and to all the members of his family. Lord Kerr had a most distinguished judicial career. A former Chief Justice of Northern Ireland, he was the last Lord of Appeal in Ordinary appointed to the House of Lords. He was a Justice of the Supreme Court from its creation until his retirement just 2 months ago. There will be other opportunities to pay tribute to Lord Kerr. At this time, I should simply refer to the immense contribution that he made to the work of the Supreme Court and to the development of the law to meet modern conditions. He was a brilliant colleague, held in great affection and admiration by all the members of the court and by all of its staff. It's right that I should record the profound sorrow of us all at the news of his passing, coupled with our immense pride in having had such a fine colleague and friend. Lord Panic.
Thank you, my lord. On behalf of Mr. Tam and myself, and on behalf of the bar generally, can I associate myself with Lord Lloyd-Jones's observations? All of us who had the privilege of appearing before Lord Kerr in this court will be especially sad to hear today's tragic news. Our condolences to Lady Kerr and to all the family. Thank you, my lord.
Thank you, Lord Panic. Your observations are very much appreciated. We're very grateful. Mr. Tam.
Please, the court. May I start by expressly saying that we on this side also would like to associate ourselves with everything that has been said by your lordship and by my learned friend Lord Panic. Lord, returning to the hearing at hand, there was one small piece of housekeeping that I need to do, that I'd lost a reference to the case of Osborne. The case starts in Authorities Volume 1, Tab 9 at EF 2425. The paragraphs to which I drew attention were 98 to 100, and they can be found at EF 2465. So I'm sorry that I'd lost that earlier.
Not at all. Thank you very much. It's most helpful.
Can I then turn to the brief submissions that I make on issue 3, which was whether TN's appeal was itself unfairly determined. On established appeal principles, there is a certain redundancy to this issue, because, of course, if the court accepts TN's argument about automatic nullity, then the question of whether her appeal was or was not fairly determined falls away, and there would be no need to look at this issue. If this court accepts, as we submit it should, the approach of Mr. Justice Ouseley and the Court of Appeal, then on established appeal principles, this court should not be revisiting or upsetting the factual assessments made by the first instance court after a fine and careful consideration of all of the facts. You will find that in Mr. Justice Ouseley's decision, paragraphs 119 to 143, starting at EF 256. That was reviewed by the Court of Appeal, paragraphs 105 to 150, starting at EF 213. And we note that the Court of Appeal itself made reference to this principle at paragraph 130, that is on EF 217. And so really there is unlikely to be any cause, we respectfully say, for the court to be revisiting or redetermining the factual aspects of this case. It would perhaps only be necessary if this court were to conclude that neither automatic nullity is correct, nor the Court of Appeal and Mr. Justice Ousley's approach, and that there was some middle ground that requires a re-evaluation. But we say that that is certainly not the situation here. That's the first point to make. There is then another general point about our system of litigation, litigation generally. The target of this judicial review challenge is the appeal determination. And the central question is whether the FTT determined the appeal fairly. Now, the FTT's function is, of course, to determine the appeal that has been brought before it. And in our system of litigation, which is usually described as adversarial, the function of a court or tribunal is to decide the case and the issues brought before the court by the parties. Now, there are a few exceptions, notably coroners, but they're nothing to do with the present case. Certainly that is true of the FTT when it's hearing asylum claims, that it's fundamentally an adversarial system where the FTT decides the issues that the parties have brought before it. So the question of whether the FTT determined the appeal fairly is really one about whether the FTT fairly determined the issues that were brought before it by the claimant. And we therefore say it's inappropriate for the fairness of the FTT's decision to be impugned by reference to issues that the appellant did not raise before the FTT, or for that matter, expressly abandoned, and which were only mentioned some time later. My Lord, Lord Stevens.
Well, my concern is it's not only the issues that the individual brought, but it's also the individuals that could have been brought by that individual if she had sufficient time to do so. So it is an aspect of the adversarial system which has to take into account what would have happened if, but only she had sufficient time.
My response to that would be this. Clearly, it is, in theory, possible that if you give a litigant more time, they may come up with a different claim or different evidence to support claims already made. But that is not a reason for granting infinite amounts of time to every litigant. And it's certainly not a reason for litigants to say, long after the event, long after the proceedings have been finally concluded, that actually, there is now something else that I want to raise that I didn't raise at the time, but because I didn't raise it at the time and I can raise it now, I now need to have my proceedings reopened. Litigation doesn't work like that.
As I understand it, and correct me if I'm wrong, the claim that she has been human trafficked is now the subject of a new claim procedure.
Exactly, and that the relationship between the appeal determination and the fairness issues that I'm discussing now and the fresh claim procedure, I will come on to in a moment. But the first step is to look at what is the FTT's function in the system that we have. Now, obviously, I accept that if a claimant or if an appellant before the FTT says, I've only had a tiny amount of time, but I do have a new claim that I didn't tell the Secretary of State about last week, but I do now want to raise it in my appeal, then obviously the FTT will have to consider that and consider whether or not it's something for which they should allow more time and to allow an opportunity to be brought. But in TN's case, we're not talking about something like that. We're talking about something that's mentioned for the first time a year later. And we respectfully say that is really not a promising basis on which to impugn the fairness of the determination which the FTT actually reached. The inquiry ought to be about what the FTT should have done or not done in relation to the issues raised by the individual appellant at the time that the proceedings were underway. Now, I entirely accept that there is force in the points made by TN and by the interveners that those who have been trafficked can find it difficult to say what has happened to them. None of us needs to have done very many of these cases to know that some trafficked people do undergo horrendous experiences. They can be under real practical pressures of many kinds to keep quiet about what has happened. And it is readily understandable why some people will not talk about their experiences until much later or until circumstances are different. And I don't mean in these submissions to downplay any of that in any way. It's reflected in the Secretary of State's own policies. And this is a fact of life. Equally, the point that I make does not seek to sidestep the international obligations which the UK owes to such people. And in this field, chiefly, they are asylum obligations under the Refugee Convention. There will be ECHR obligations, and there will be obligations to people who have been or may have been trafficked. But these obligations are obligations which are owed by the state as a whole, by the United Kingdom as a whole. What would be wrong would be to dump the burden of all of those obligations solely onto the FTT and onto the conduct of the first appeal process. The FTT has a particular place in the UK structures for handling the cases of such people. It has within our system of litigation a particular place and a particular function in dealing with the issues that arise. And this is why, even after the final dismissal of an asylum claim and an asylum appeal, it remains open to an individual to make a fresh asylum claim, and then the UK must consider it. Initially, that is done through the Secretary of State, but if necessary, there may be a further trip to the FTT for a further appeal if the fresh claim is refused. So if somebody says much, much later that they want to make a fresh claim, the answer with respect is not to say, well, therefore, the original FTT determination was unfair because the FTT didn't allow the weeks, months, or years necessary for this fresh claim to merge. The answer is to let the entire system do its job. And that is, in fact, what is happening in these cases. Now, all of that is pretty basic stuff, but we thought that it was worth saying and bearing in mind when one looks at the headline points about TN's actual claim and therefore whether the FTT dealt with it unfairly. I'm not going to go through all the detail because this is not an occasion for making detailed factual submissions, but can I point to where these things are set out? Our argument is set out in our printed case. At paragraphs 5.1 and 5.2, we analyse out the different claims that TN has made at different times and the broad phases of her history to which they relate. That is EF 162 and 163. We make detailed points about her claim from paragraph 5.6 to paragraph 5.25, that's EF 164 onwards. And in particular, we make a number of points about the changes in her story over the years at paragraph 5.21 at EF 170. May I please invite attention to all of that, which sets out more clearly than I can possibly do orally in the short time available, what our case is. But I do want to just run through the headline points. And they are the following. When she was first in the UK, her asylum claim was one about generic persecution of Catholics in Vietnam. In the conduct of that asylum claim, two men gave evidence in support, and she described them as friends, and I think she said they were like family. But after the failure of that claim, she was removed to Vietnam in 2012. If you need references in the Statement of Facts and Issues, they're paragraphs 32, 34, and 36 at EF 81. When she returned to the UK, she said two things. First of all, she made a different asylum claim, because this was now based on specific events that she said had happened to her mother and to herself after her return to Vietnam. And that's paragraph 41 of the SFI at EF 82. There is the oddity about the different accounts that she's given of her mother's death, which my Lord Stevens, I know, has mentioned already, and that is set out in the papers. The second thing that she said was that she had been raped en route to the UK. And that is recorded in the SFI, paragraph 37, EF 82. Now, when that asylum claim came before the FTT, and that is the determination with which this case is concerned, she expressly declined to pursue a claim based on having been raped on the way to the UK. And that's distinctly different from the position that she might hypothetically have taken, which was to say, well, I haven't been able to have enough time to adduce evidence in support of that, but you'll have to decide this claim anyway. She expressly declined to pursue it. You will see that at paragraph 54 of the SFI EF 86, together with the fact that at that point she was legally represented. So there can be no question of her having done this accidentally through a lack of expertise. The result of that was that, for whatever reason, the decision not to pursue the claim about rape en route to the UK, it was not before the FTT, and it was not the FTT's function to decide that claim. The FTT did, of course, decide the claim that was before it, recorded at SFI 55, EF 86. And when that was dismissed, the Secretary of State then set removal directions, SFI 59 at EF 87. The first JR that TN brought challenged those removal directions. That's SFI 59 at EF 87. There was no mention then of any claim of being trafficked or exploited within the UK, which is the third of her three claims. And that JR was dismissed. That's recorded at paragraph 62, EF 87. Further removal directions were then set by the Secretary of State, by now a year after the FTT's determination. That's SFI 65 at EF 88. And it was 2 days before her removal in pursuance of those directions that her then solicitors advanced a claim, first of all, about being a victim of trafficking on the way to the UK. So that's resurrecting the claim about being raped on the way to the UK. And then for the first time, raising a claim about being a victim of trafficking within the UK, alleging, amongst other things, that one of the men involved in supporting her first claim was actually involved in the trafficking. And you see that at SFI paragraph 66 at EF 88. Now, because of Mr. Justice Ousley's decision, there is now a claim that the Secretary of State has to deal with. If the Secretary of State refuses that, there will be an onward appeal, a second appeal to the FTT. So I want to be careful about what I say about the merits of all of that. But as my Lord Stevens has said, there is an oddity in that there's no direct evidence from TN at any stage during this judicial review setting out her own account of what she says her case now is, or advancing any explanation as to why it's changed. But in any event, that chronology of how the claims have been made at different times, and the long gap between the dismissal of the first asylum, sorry, the dismissal of the asylum appeal that is under challenge here, and the making for the first time of a claim of being trafficked within the UK, shows that whatever you say about it, the one thing that is clear is that the FTT was not unfair in determining the issues that it had to determine. And therefore, we respectfully say Mr. Justice Ousley and the Court of Appeal were correct to say that the FTT didn't unfairly determine that appeal. On the basis of what the FTT had and the issues that it was its function to determine, it was an appeal which called overwhelmingly for dismissal, not least on the credibility points that we have identified. Any other conclusion would involve a finding that despite the fact that the that TN was only raising those or that one claim before the FTT, that the FTT should somehow have refrained from determining that and allowed TN some unspecified period of time in which, for all the FTT knew, she might or might not have then produced a further claim of an entirely different nature. Clearly, it is not right for the new claim to be ignored by everyone. But that was never going to be the position. The Secretary of State has always had to look at that. Mr. Justice Ousley's decision means that it is now a claim which, if refused, will lead to a further right of appeal to the FTT. That, we respectfully say, is the correct way in which the system should deal with this. It is quite wrong in principle to say that because of all the things that happened a long time after the FTT's determination, somehow the FTT should now be said to have determined her appeal and the issues that she raised then unfairly, with all the consequences that would then follow. So on issue 3, for all of these reasons, we respectfully say that Mr. Justice Ousley and the Court of Appeal were in any event correct, and so there is nothing in this either. Lords and Ladies, those are my submissions on issue 3. Unless there is anything else on which I can assist the court, those are my submissions on behalf of the Secretary of State, and I apprehend that learned friend Miss Anderson on behalf of the Lord Chancellor will simply adopt what I have said on behalf of her client.
Thank you, Mr. Tam. I don't think there are any questions for you at the moment. We're very grateful. Thank you. Ms. Anderson.
My lady and my lords, I do, as Mr. Tam anticipate, gratefully adopt his submissions on behalf of the Lord Chancellor. I have nothing further to add.
Thank you. Thank you very much indeed. Thank you. Well, Lord Panic.
Thank you very much, my lord. Mr. Tam says that the appellant must show that there was unfairness on the facts of the appellant's case. We say that the application to her of asylum appeal rules, which were unfair and unjust, is unfairness enough. And that is because the unfairness in the rules was not theoretical, it was not abstract. Every decision that was taken in her case was taken under the pressure of the unfair timetable. All of the preparation for the appeal, all of the decisions, all of the statements made on her behalf at the appeal hearing were, in our submission, inherently infected by the unfair structure of the rules as identified by Lord Dyson's Court of Appeal. Every step taken or not taken as to the obtaining of evidence, the deployment of it, and the strategy at the appeal hearing was inevitably done by reference to the rules which applied, including, not least, as Lord Dyson said at paragraph 43, it's EF 2310, the impossible dilemma imposed on the appellant as to whether to seek more time to present her case, with the adverse consequence of advertising any weaknesses in that case. We emphasise, and we adopt Ms. Kilroy's submissions yesterday, we emphasise that Lord Dyson's Court of Appeal did not just decide that there was a risk of unfairness. The Court of Appeal decided that these rules were inherently unjust and unfair. It's paragraphs 45, 48 and 49 at EF 2311 to 2312. Because of the unfairness in the structure of the rules, this appellant, like many others, was denied a fair opportunity to appeal. The right conferred by Parliament, Mr. Tam did not address the statutory context, but the right conferred by Parliament in section 22 of the Tribunals, Courts and Enforcement Act of 2007, it was Authorities Volume 2, Tab 17, EF 2661, was expressly to a tribunal system which is fair. That's what Parliament required. Why did Parliament so require? Because Parliament understood, particularly in this context of asylum appeals, given the gravity of the issues which arise, that only a fair system can ensure that there is fairness in practice for individual appellants. The crucial authority in my submission is Miller and Dixon, the bias case. My friend Mr. Tam seeks to distinguish Miller and Dixon on one ground. He points out accurately that every single temporary sheriff lacked independence and impartiality. And he's right. But just as every temporary sheriff lacked independence and impartiality, and so every hearing conducted by such a person lacked procedural fairness, irrespective of the specific impact on any particular defendant, so we say every fast-track asylum appeal was under rules which were inherently unfair and unjust, irrespective of the specific impact on any particular appellant. And my lady, Lady Arden, asked Mr. Tam a question about this. And in my submission, it's a very important question, because Mr. Tam said that he accepted that the procedural defect may be so serious that it would apply in every case, with the consequence that every person subjected to such a system would be entitled to an individual remedy. And he, Mr. Tam, gave the example in answer to my lady of suppose there was no right to be heard at all. I say it's a very fine line that Mr. Tam is inviting the court to draw. Here, the rules have been found, there's no dispute about it, they've been found to be inherently unjust and unfair. We do not, in my submission, need to show that they are unfair or unjust to any greater extent. There are not levels of procedural fairness like the housemaid's baby. One can't say it's only a little one. I'm sure that's a politically incorrect analogy to draw, but I draw it nevertheless. The position is these rules were unjust and unfair, and it is nothing to the point that one can imagine even more unjust a system, by reference to which Mr. Tam would accept, as I understood him, that the consequences for which we contend would then apply. And indeed, if there are levels of procedural unfairness, we do say that to impose rules for asylum appeals which are unfair and unjust is a very, very serious matter, given the gravity of the issues which are at stake. I drew attention yesterday, and my friend doesn't dispute the proposition that there is a need for the highest standards of procedural fairness in asylum appeals, given the gravity of the issues that the court is considering. See the Tonaghmore case. My lady asked in a question to Mr. Tam whether the test is really whether there is material unfairness. We say that the unfairness is material in this context because the appellant's appeal was heard under unfair rules which put her at a serious disadvantage for all the reasons given by Lord Dyson, a serious disadvantage in presenting and conducting her appeal on the asylum issue. One other question that my lady raised, my lady put the point to my friend Mr. Tam that an appeal to the upper tribunal might have cured the structural unfairness in the first tier tribunal. I say not merely has that never been raised until today as an answer to our complaint, but in principle, the possibility of such an appeal is no answer. Permission to appeal was needed to take the matter to the upper tribunal, and there were very strict time limits, as one would expect, given the consistency of the scheme. There were very strict time limits on such further appeals, consistent with the accelerated timetable. And in any event, an appeal to the upper tribunal is only for an error of law. The appellant would have lost her right to a de novo appeal before the first tier tribunal. And for such reasons, I invite the attention of the court, if this matters, to what Mr. Justice Nicholl said in 2015, his judgment, of course, being upheld by Lord Dyson's court. Mr. Justice Nicholl, if I can give the reference, it's paragraph 82 at EF 2297. His lordship said that if, as he found to be the case, the first tier tribunal rules were ultra vires for unfairness, the upper tribunal rules, quote, which are parasitic on them, must also necessarily be ultra vires. Mr. Tam made a submission to the effect that if we are correct, even appeal decisions in which the appellant had succeeded would be vulnerable to challenge. And we respond, this is, with great respect, not the most realistic of submissions. First, because, as I submitted, and Mr. Tam does not dispute, an appeal decision is only vulnerable if an application is made. See Smith and East Ello, which I took the court to in opening. And a successful appellant is not going to challenge an appeal decision in her favour. Nor is the Secretary of State going to challenge an appeal decision that upholds the appellant's position. I assert that because that's what the respondents themselves say in their own written case. I give the reference, paragraph 3.28 at EF 156. And indeed, were the Secretary of State to challenge a successful appeal decision on the basis of unfair rules, the court would inevitably, in my submission, tell the Secretary of State that she could hardly rely on the government's own failure to enact fair rules as the basis for challenging a successful appeal. And finally, this suggested anomaly, and it's not an anomaly, didn't deter the Privy Council from making the decision it made in Miller and Dixon that every defendant was entitled to overturn a judgment against them, conviction against them, or a sentence against them, presided over by a temporary sheriff who lacked independence and impartiality, even though it could not be shown, it wasn't even asserted, that this defect had any effect whatsoever in the circumstances of the individual case. Indeed, the court will recall some of these defendants had actually pleaded guilty. Then my friend Mr. Tam took the court to a number of cases that address the concept of structural unfairness. And could I invite the court just to go back to those cases? The first of them is Re Q. Could I invite the court, please, to turn to tab 11, which is EF 2544. This case I personally remember very well because I was led by the Attorney General, Lord Goldsmith, who at the time was advising the Prime Minister on the start of the Iraq War. And he was turning up at 10:30 every morning in the Court of Appeal, having done whatever was necessary before them. It was a quite remarkable performance by Lord Goldsmith. And as the court has heard, what the case concerned was the fairness of the process for deciding whether asylum seekers were entitled to support under the 2002 Act, support that was dependent on whether they had claimed asylum as soon as reasonably practicable after they'd arrived in this country. And what the Court of Appeal found, upholding Mr. Justice Collins and dismissing an appeal from his judgment, the Court of Appeal agreed with him that the system was not fair or fairly operated. And my friend has shown the court the relevant paragraphs on that, in particular at 2584, where paragraph 85, where the Court of Appeal accepts that the system operated by, or more accurately on behalf of the Secretary of State, is not fair. It wasn't a fair system in a number of respects. And the respects were set out at 2592, in particular at subparagraph 12, just above letter E, which my friend read to the court. Now, what Mr. Justice Collins did was to quash the individual, the decisions in the individual cases. One sees that in the summary at EF 2551 at letter D. And the Court of Appeal upheld that remedy. And we see that at 2588. These are two paragraphs which my friend did not read. I don't criticize him, but for a full analysis, one needs to look at 2588. And at paragraph 108, they comment on Mr. Justice Collins' finding. And then in the final sentence of 108 at EF 2588, they say, we agree with him, Mr. Justice Collins, that the process adopted to date has not been intrinsically fair. I emphasize those words. 109, in these circumstances, in other words, when the process has not been intrinsically fair, we do not think that it is necessary for us further to discuss the facts of the individual cases. Secretary of State will no doubt reconsider them as appropriate in the light of the conclusions which we have reached. However, the appeals in the individual cases must be dismissed. That's the appeal by the Secretary of State. Now, I say that is a recognition consistent with our submissions that where the process is intrinsically unfair, And where it has been applied to individual applicants, that is of itself sufficient to justify a remedy for each of the individuals to whom the unfair process has been applied. Then my friend relied on the Refugee Legal Centre case, which is tab 12 at page EF 2601. And my friend drew attention to page 2605, the second half of paragraph 6 of the judgment of the Court of Appeal. And at letter B, it's Lord Justice Sedley, I think, speaking, yes, for the court. At letter B, the question posed by my friend Mr. Tam is, does the system provide a fair opportunity to asylum seekers to put their case? That was my friend's analysis of the issue, and it receives the support of the Court of Appeal. A more appropriate question, in our view, is the one posed by my friend. And we agree, that is the question. Does the system provide a fair opportunity to asylum seekers to put their case? And the answer in the present case is no, it didn't. That's what the Court of Appeal found. Now, in that case, at paragraphs 20 and 21, the complaint was rejected. At paragraph 20, which is on page EF 2609, Lord Justice Sedley asks the question, does the present system, considered in the round and at the point of entry, carry an unacceptable risk of unfairness to asylum seekers? In our judgment, Mr. Justice Collins was right to conclude that it did not. So even asking the question about risk, the complaint there failed. In our case, the complaint succeeded not by reference only to risk, but by reference to actual unfairness. One other paragraph, although it is, of course, obiter, is paragraph 24, obiter in the light of that finding. Paragraph 24, on the next page, 2610, Mr. Fordham, for the applicants, invited us to find against the Home Secretary on essentially the same footing as the court did in Q, the case I've just shown the court. There, the essential finding was that the procedures applied to each of the applicants had been vitiated by unfairness to him or her. There is, however, a difference between that case and this. There, the deficiencies in due process had resulted in adverse decisions which fell to be quashed in consequence. Here, what has been identified as a gateway risk of injustice, but caused by potential rigidity in a system which requires genuine flexibility in its timetable. We have recognised this risk, indicated what in our view needs to be done to obviate it, but like Mr. Justice Collins, we do not consider that the system itself is inherently unfair and therefore unlawful. So again, I do not accept, with respect, my friend's analysis. I say that Refugee Legal Centre, faithful to Q, acknowledges that where there is a finding that the system, to use the language of paragraph 25, is inherently unfair and therefore unlawful, a remedy will be granted to each of the applicants to whom that unlawful, unfair system has been applied. The final case that my friend relied on in this context was the recent judgment of the Court of Appeal in FB, which is at tab 7, my lords, my lady. And as the court saw this morning, the complaint that was upheld by the Court of Appeal was that the policy of removing those without the right to enter or remain in this country after a short notice period was unlawful because it frustrated the right to access to justice. This is a sensitive issue, but that was what the Court of Appeal found. You can't just remove people on short notice. You have to give them a proper opportunity to obtain access to justice through judicial review. And that finding was explained by Lord Justice Higginbotham for the court, as my friend indicated, at page EF 2384 at paragraph 147. For these reasons, in my view, the policy with which we are concerned incorporated an unacceptable risk of interference with the right of access by exposing a category of irregular migrants to the risk of removal without any proper opportunity to challenge a relevant decision in a court or tribunal. Now, what my friend relied upon was the findings in relation to the individual claim, which starts at EF 2385 and continue over to 2386. And at paragraph 156, which is on EF 2385, His Lordship says, I can deal with FB's individual claim briefly because, irrespective of the risk that irregular migrants in general might face, the tribunal held that FB was not in the event denied access to justice as a result of the operation of the policy or otherwise, and FB does not seek to challenge that conclusion in this appeal. There then follows a detailed statement of what happened in FB's case, and at 163, which is on page 2386, the summary is that FB thus complains that from a particular period he was at risk of removal. However, as Ms. Nake for him accepts, in the event he was not in fact denied access to justice, and so no relief specific to his individual case is required or appropriate. And the reason for that, my lords, my lady, is that the fast track approach, we're going to remove people after a limited period of time, was not in fact applied to FB. The time limits did not apply in his case. It seems by accident rather than design, but nevertheless he was not subjected to the policy, and it's therefore not surprising that he doesn't get an individual remedy. Contrast, in my submission, the present case where the fast track rules were applied to the appellant. She was subjected to an appeal process under which the strict time limits criticised by Lord Dyson's Court of Appeal were applied in her case. My friend then moved on to consequences, and he emphasised the need for finality, for legal certainty. And I've already referred to the observations for the court by the late Lord Kerr in DN Rwanda. It was at EF 2327. I don't go back to it, it's paragraph 20. But I do remind this court of what Lord Kerr said. Finality and legal certainty are desirable objectives, but they cannot extinguish a clear legal right, unquote. That's paragraph 20 of DN Rwanda, page 2327. Here, the relevant right is the right, as guaranteed by section 22 of the 2007 Act, to a fair appellate system. And this all echoes the very familiar dictum of Lord Atkin in General Medical Counsel and Spackman, 1943, appeal cases 627, 638. I quote, "Convenience and justice are often not on speaking terms." Mr. Tam emphasised the consequences if our submissions are correct. Well, such problems as will occur are caused and only caused by the creation by the government, the Lord Chancellor, but applied by the Secretary of State, of rules which were structurally unfair. They are the authors of any misfortune. And in such circumstances, I do respectfully submit that it does not lie in the mouths of the respondents to seek to deny appellants what Parliament conferred on them, which is a right to an appeal under a fair system, especially when, as I have submitted, we're dealing with asylum claims where the consequences are potentially so grave. But that's what I want to say, subject, of course, to any further assistance I can give on issue 1. May I, and I speak with Miss Harrison's consent here, may I briefly address also issues 2 and 3. On issues 2 and 3, we do say that one or more of the factors to which Lord Dyson drew attention as the basis of the structural unfairness was material in this appellant's case. We can establish unfairness on the facts by reason of the operation of the rules, if that's what we need to do. And what we know, there's no dispute about this, what we know in this case is that when more time was available, medical evidence was produced. And that evidence has been accepted by Mr. Justice Ouseley as raising a real prospect of a different outcome. That was his finding. It's paragraph 147 at EF 263. I don't need to establish that there will be a different result, of course, and Mr. Tam doesn't suggest that I do. But I can establish that when more time was taken, the medical report raises, in the view of Mr. Justice Ouseley, which is not challenged, a real prospect of a different outcome. And the need for time, more time than the fast track rules allowed, the need for time to obtain expert evidence on precisely this sort of question was one of Lord Dyson's concerns. See EF 2305, it's paragraph 20, Roman 7. And these are not new points. In the interview, the appellant did claim that she had been tortured. See, well, it's in the Statement of Facts and Issues, is the most convenient place to see it, paragraph 47 at EF 83. She, and that summarizes her interview. She said at her interview that she had been tortured. That was her allegation. It was interview EF 757, questions 48 to 51. And that same medical report, which Miss Harrison read parts of it to the court yesterday, does support her claim of trafficking and explains the manner in which she made these claims is not surprising if one considers the pressures on someone who has been trafficked. And that also appeared in the interview. It's in the Statement of Facts and Issues, paragraph 48 at EF 84. That summarises the interview. And the interview itself, if the court needs to look at it, is at EF 761 to 762. So I do say, if I need to go this far, and the court has my submissions that I don't, if I need to, I can show that the fast track rules, with the exceptional speed at which claims had to be considered, did impose a detriment in that when more time was available, a report has been produced that provides at least a properly arguable basis for a different substantive result. And indeed, my friend Mr. Tam expressly acknowledged the need for such care in a trafficking case because of the reluctance, understandable reluctance of those who are genuinely the victims of trafficking to speak out without first accepting confidence in those who are advising them, and the profound problems that such conduct causes. Can I add this? It does not assist my friend Mr. Tam on issues 2 and 3 in my submission, or at all, to say that the FTT acted fairly in considering what was put before it. Now, that's no answer in my respectful submission. If the rules prevented a fair hearing, issue 1, or if the rules had a material effect on this appellant, issues 2 and 3, and I've just dealt with that, then the FTT decision cannot stand. Suppose the rules provide for a hearing, but they prevent cross-examination of an adverse witness, or they deny representation by lawyers, or some other serious defect. It cannot be an answer to say, well, the FTT acted fairly within the limits imposed by the rules which the Lord Chancellor had laid down. That cannot be an answer. If there's unfairness, then the decision made by the FTT cannot stand, whoever is responsible, whether it be the FTT or whether it be the maker of the rules that they are obliged to apply. One other point, my lords, my lady, Mr. Tam emphasised at the end of his submissions that if his approach is correct, the appellant will still enjoy a right of appeal in relation to the fresh claim, the one that Mr. Justice Ouseley accepted can now go ahead because there is this medical evidence in her case. Can I show the court what was said about this by Mr. Justice Ouseley? It's at EF 262 in his Lordship's judgment, paragraph 143. EF 262. He says, first of all, at 143, if I had concluded differently on the issue of fairness, I would have quashed the appeal decision. The subsequent fresh claim decisions would have fallen away, not because they were tainted by unfairness, which may or may not have been the case, but simply because they assume that there has been a concluded appeal. That would have been an incorrect assumption. The fresh claim decisions cannot themselves stand in the place of a fair appeal decision. And therefore, he says he wouldn't have refused to quash the unlawful appeal decision. In other words, it's all well and good for the appellant to have a fresh appeal decision. But what she wants to avoid, and in my submission is entitled to avoid, is that fresh appeal decision proceeding on the basis of the earlier appeal decision, which has made the findings that are damaging to her case. And indeed, our submission on this point also has the support of what is said in the respondent's own written case. This is my final reference, EF 145. If I could ask the court, please, to turn that up. EF 145 at paragraph 212. This is the respondent's written case. EF 145, paragraph 2.12. The respondents acknowledge at once that the ability of an unsuccessful claimant to make a fresh claim would not be an answer to a valid complaint that his earlier asylum appeal was unfairly dismissed. That unfair dismissal should result in the quashing of the appeal determination so that the original asylum appeal would have to be redetermined rather than leaving the claimant to resort to pursuing his fresh claim. And that's because, as I said, otherwise the fresh appeal is on the back of the earlier tribunal having rejected the rest of her case. So we say we respectfully agree with paragraph 212. My lords, my lady, that's what I wanted to say by way of reply, subject, of course, to any further assistance I can seek to give to this court. I'm grateful to the court for its attention to these matters.
Well, thank you, Lord Pennick. We're grateful. We're grateful to all counsel for your very helpful submissions. We will take time to consider our judgments in the matter. I should also say we're very grateful to all those who, metaphorically at least, sit behind you, because a great deal of work has gone into the preparation of this case, and we are very appreciative of that as well. Thank you all very much for your assistance. Court's now adjourned.